the allegations of sexual assault. The defendant had nowhere to go, and he was left in the residence to be, only have supervised visit with these 8 minor children. The victim in this particular charged case is 9 years old, and the allegations are that he rubbed her so hard in her face while she was in the shower that he scratched her and she was bleeding. And
good morning, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Code 8.120.
Code?
Michigan Rule.
Court Rule.
Court Rule 8.120 under the supervision of Mr. Jay Bellinger, representing my client, Nathaniel Gray.
Permission to practice is granted.
Thank you, Your Honor.
All right, what are we doing?
Your Honor, we are requesting a 2-week adjournment so that we may consider continue going over discovery.
Probable cause conference in this matter will be adjourned July 25th, 2024.
Thank you, Your Honor. May we address bond?
Yes.
Thank you, Your Honor. Your Honor, my client is seeking a lower bond if possible. He has 3 kids and another on the way. My client would like to continue working if possible so that he may continue to provide for his family. He has the support of his family. He is a church-going man, and he would just like to continue being supported by his family. He is willing to do an alcohol tether if need be so that he may continue to work while being monitored by the courts. I did want to note that he is being held on a probation violation in the 22nd, but
what's his bond in that case?
I waited until I finished with this to figure out what I was going through with this.
He's only been arraigned in that matter.
Pardon?
He's only been arraigned in that matter.
Okay, so what's his bond in that case?
I have no bond right now. I'll go Tuesday.
So it's no bond?
Right now, yes, sir.
Okay. So how did he come back into custody on this matter? Because he failed to appear back in March of 2024.
I got stopped.
You got stopped, so he didn't turn himself in?
No, Your Honor.
Anything else?
No, Your Honor.
Bond reduction denied. Bond will continue.
Thank you, Your Honor.
On behalf of probation, Your Honor, Mr. Olson is before the court for a violation of probation hearing. Mr. Olson was sentenced in this case December 13, 2023. Mr. Olson has done nothing with his probation. He failed to report after sentencing. He owes a balance of $1,525. He's made no payments. He failed to sign and return his probation order, failed to complete substance abuse treatment, the assessment and/or treatment, including a mental health assessment and/or treatment. He failed to report to community corrections for his random weekly drug testing. And he has also failed to report to this court on prior violation of probation hearings in April, May, and in June. He would then submit a bench warrant recall request that again and again he would not appear. Given all of that, probation is asking that the court sentence him to 93 days in jail, credit for 25 days served, to serve the balance, complete the in-jail Dawn Farm program, waive remaining terms, accept his financial obligations, and discharge him from probation without improvement.
I did speak with Mr. Olson regarding the VOP. I think Mr. Olson's issue has been that he has tried to complete some of the terms, but has not fully been able to get there. For example, when I was reading through what he hasn't done, he said, well, I did call probation, but he didn't show up in person. When I read that he didn't do his treatment, he said, well, I did call Bear River, but I wasn't able to get up there.
Bear River comes and gets you, but go ahead.
Or hasn't been able to complete the intake or whatever happened.
Yeah. Okay.
I think his limitations come from he told me he's not working. He doesn't have any transportation. He doesn't have a car. He doesn't have a license. He's been living with his mother and taking care of his pregnant fiance. He's been trying to keep his head above water. I will tell the court
How did he get picked up?
his mother.
My mother was going out of country to deliver a package. She's a package carrier. I had to wake her up to find out when she'll be there because I was planning on going to work, and the police department, the state police picked me up.
I think he's been trying to keep his head above water, trying to care for his pregnant partner, trying to get work, trying to help support his mother. I do know he has the support of her. As the court may know, she's called probation, she's called the prosecutor's office, she's called my office, she's called the court, trying to get someone to help Mr. Olson. I do think if he were in touch with Ms. Pilara, he would be successful in probation, but that connection hasn't been made, obviously. I think Mr. Olson is someone who needs a little bit more support to complete the terms. I mean, he expressed a lot of confusion to me about what he needed to do and what was going on. I think he's been struggling with, like I said, completing the things he needs to do without someone kind of ushering him through it. He does have more time on probation. I'd ask the court to give him a chance to complete the terms that he needs to complete.
Anything you want to say, sir?
I apologize for anything I've done wrong. And
April 10th of 2024, I had to issue a bench warrant because you didn't show up at your violation of probation hearing. You submitted a recall. We reset it. May. Same thing. Didn't show up. And issued a recall. Usually we wouldn't recall it. We recalled it. We reset it in June. June 12th comes around. What happens? You don't show up. I would agree with everything Ms. Perrine says in terms of, yeah, you might need help getting through some of this. Maybe. I don't know. But it's impossible for us to determine because anytime that we're setting a hearing for you, you're not here.
yes, sir. That's why I was apologizing, sir. Your Honor.
Sentence of the court, 93 days in jail, credit 25, defendant to serve the balance. He's to complete the Dawn Farm in jail program. I'll waive remaining terms, accept his financial obligations, discharge him from probation without improvement. Thank you.
Your Honor, I'm not really seeing, never saw my probation officer and they told me 10 days.
What?
They told me 10 days the last time I spoke to them.
They told you 10 days for what?
I think that he's referring to a prior hearing.
Cowan.
Good morning, Your Honor. Rise or claim on behalf of the people.
First Assistant Public Defender Queen Anderson with on behalf of Mr. Cowan, who's approaching.
Mr. Allen, who is that at Ann's window? Is that somebody from the PD? Attorney? Okay, not properly attired, but okay, I understand. Go ahead,
Did you need me to do something, Judge? Oh,
unless you have a jacket and clothing for someone. Go ahead.
you don't have had a chance to speak. I'm sorry, Mr. Cowan, can you put your name on the record? Say your name.
Thank you, sir.
Your Honor, I've spoken with the prosecutor about this. It's my understanding that the investigation is still ongoing on this and that there may be additional charges. Based on that, I'm asking to adjourn the probable cause conference for that purpose. I would defer to the prosecutor as to the length of time required. And then I'd ask for the opportunity to address his bond.
There was an additional forensic interview done on Monday, so if that should be submitted, and I would anticipate having that charge next week. So
The chart. Got it. So 2 weeks out. All right. So probable cause conference, July 25th, 2024, 9 a.m. On briefly.
Mr. Bond, this is the only matter that's holding Mr. Cowan in custody. Case to me, he does not have any prior criminal history. He's concerned about his housing. He's unsure whether or not rent has been paid, or not he still has a home at this point. He's retired. We did go over the bond conditions of the no contact and no ghost. He would be able to abide by that. I've spoken with his sister and confirmed that he can reside with her in Detroit while this matter is pending. Mr. Cowan does suffer from some medical issues as well, kidney stones. He also has an inflamed colon. And those services at the jail, and he is receiving Motrin, but that's really not helping with the pain. He's asking for the court to reduce the bond. Currently, his bond, I believe, is $100,000. That's a bond that he's not able to post. He has been in since June 26th. He does have the support of his family, which I believe some of his family members are here in the courtroom in support of him. We understand that the court's unlikely to give him a personal bond, but he's asking if the court will reduce the bond or at least allow a 10% privilege on the bond that's currently set.
Response.
And Your Honor, we would ask that the bond continue until the time of preliminary exam. There are 8 minor children living at this residence. The victim, in this case, in addition to another minor child, have been interviewed. And at the time that CPS came to the residence, the allegations, when CPS was called out to the residence for the allegations of sexual assault, the defendant had nowhere to go. And he was left in the residence to be, only have supervised visit with these 8 minor children. The victim in this particular charged case is 9 years old, and the allegations are that he rubbed her so hard in her face while she was in the shower that he scratched her and she was bleeding. And so I believe he is a danger, not only to the community, but to these children. The 12-year-old, one of the 12-year-old boys that was interviewed said that he watched pornography on a regular basis with his dad, observed his dad having a 14-year-old sister. So I think the allegations are very serious, and we would ask that the bond continue until the time of the preliminary exam when that is set. And
The new or the forensic evaluation, does that involve someone different than
a different victim, another minor child.
Another minor child other than the one in this one?
Your Honor, may I address part of that argument?
Sure.
Your Honor, the prosecutor stated that at the time he didn't have somewhere to go. As I stated to the court, he does now have somewhere where he can go and stay with family. It's also my understanding that the complainant in this case was taken to the hospital and that the allegations were not substantiated. I'm expecting the prosecutor will be providing me with copies of medical records to show that.
In which?
In this case, the original
In
case.
this case,
Yes.
then I have potentially either a new case or other charges coming regarding another child.
That's our understanding.
And
That's
I would
it.
just ask Your Honor that bond conditions contain this, but indicate that there should be no third-party contact.
That it indicates that.
Okay.
So, but based upon that there are other charges coming, I get, Ms. Anderson, what you're saying, but the court at this time is going to deny your motion for bond reduction. Bond in this case will continue.
Thank you, Your Honor.
Thank you. Court does call the case People v.
This hearing brings together multiple layers of the justice system: probation violations, bond arguments, and serious criminal allegations, all in one session. On one side, we see defendants asking for leniency based on personal hardship, health issues, and family responsibilities. On the other, the court is focused on patterns of behavior, missed hearings, lack of compliance, and in the most serious instance, allegations that raise significant concerns about community safety. In the end, the judge's decisions reflect a consistent theme: accountability matters, and trust must be earned through actions, not just words. Now we want to hear from you. Do you think the court made the right calls in these situations? Should more weight have been given to personal circumstances? Or was public safety the priority here? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.